Everybody, this is Tracy here with another edition of A View from Tracy's Point, and we are here today to do another R. Kelly update video. There really isn't much to report on that's taken place, but I was able to get the motion that was filed by Steve Greenberg, the prosecution's response to his motion, and then there's a letter that I also want to talk to that was sent to the judge in the New York case. And so, for starters, R. Kelly had a hearing in the Eastern District of New York yesterday. He did not appear at that hearing, but Steve Greenberg appeared on his behalf, and the courts denied his motion to be released and to go back to his apartment or wherever and be under the control of the courts, where they would monitor him and make sure he not go anywhere. And so this will probably mean that when the Illinois, the Northern District of Illinois, hears the same motion, they are going to deny it also. And I'm thinking at this point it really doesn't make any sense for Steve Greenberg to even follow up with the motion with the Northern District of Illinois, because they're going to say no. And then this all relates to the Chicago case, because remember, the Judge Flood said that he would not revisit the state's request to increase R. Kelly's bond if the federal cases did not grant him the motion for release. So that's a done deal as well. So it'll be interesting to see if Steve Greenberg actually still puts his motion before the Chicago or the Illinois federal case, or if he'll just let it go. And then remember the guy down in Mississippi or somewhere that's suing R. Kelly because his wife was dating R. Kelly before they got married, and she promised him that she would stop seeing R. Kelly, but then after they got married, they up and moved to Atlanta, and so now he's suing R. Kelly for breaking up his marriage. Well, we've learned today that he actually had R. Kelly served in court, and so now he is asking a judge to give him a judgment in the case because R. Kelly hasn't shown up. But we all know that R. Kelly was arrested like right after the guy filed his last motion back in July. R. Kelly was arrested, like a couple of weeks later or whatever. And so now he's trying to get a judgment against R. Kelly because R. Kelly is unable to respond to his motion, which is crazy. I hope that the judge just throws the whole case out, but we will have to wait and see. And so what I'm going to talk about for the remainder of this video, well, actually, I'm going to tell you guys something that happened today that I thought was hilarious. But what I'm going to get into today is because you guys know I love bringing you information when I can. And so I have the actual motion that Steve Greenberg filed with the Eastern District of New York for R. Kelly's release. And then I have the prosecution's response to that motion, and we already know that the judge declined to let him out or to give him that release, which took place in court yesterday. And then there is a letter that I want to talk about and just give my thoughts on that letter. But before we get to that, Kevin Terrell. Okay, y'all go follow on YouTube is DeeJay DeeJay Tyson Tyson, but on Facebook is just Kevin Terrell, and he has a couple of pages, but usually when you type in Kevin Terrell, I think his is like the first one that pops up. But you can go and watch this live that he did today, and I was kind of like having a dragging day, slow day, just kind of still, feeling the emotions from the Amber Guyger trial. If you haven't been following that, I have 3 videos up about that trial, and that was where she was a former Dallas police officer who killed a black guy named Botham John. She said that she thought it was her apartment, and she entered his apartment and shot and killed him. Well, she was found guilty. The prosecution was looking for 28 years minimum for her, and the jury could have given her up to 99 years, but instead they opted to give her 10 years, and then there was some theatrics going on after the sentencing verdict was read. And so you can go check those videos out, but I was just really exhausted just from that whole situation, upset, bothered, about what was going on. So I needed a laugh today, and that laugh came in the form of Kevin Terrell, and I'm telling y'all, go check that video out. I'm not sure if he's going to put it on YouTube, but if he does put it on YouTube, I'll go ahead and drop the link in this video, and it'll be at the top of the video. But Kevin, it was his lucky day because he ended up talking to Dana J. He talked to Don Russell, and he talked to somebody named Darlene, a fan named Darlene. And when I tell y'all, it was a hot ghetto mess, okay? So Kevin needs to be on R. Kelly's team when it comes to interrogating the witnesses because he interrogated Dana J, and y'all know how Dana be trying to deflect and go off in left field, but Kevin kept bringing him back. Like, no, I need answers to these questions. And he, the video is like an hour long, but I think about 30 minutes of it was him talking to Dana J. And so I think what was interesting from the whole part that he was talking to Dana J, he was asking Dana about, being the father of Ashanti McGee's, one of her grandchildren, and then also having fathered a child with Rashana Landfair, who you guys know is the person that everyone claims is in that R. Kelly video. So Dana was like, I don't want to talk about it. I don't want to talk about it. But if you remember, he was the one. It wasn't like people went and dug this information up on him. He was the one that brought up the fact on one of his Facebook Lives that he had a child from Ashanti McGee's daughter. And so Kevin was basically asking him, like, I don't understand how you fraternizing with the enemy, but then you still saying that you 10 toes deep for R. Kelly. So I just need you to help me understand what's going on. And so in the video, Dana, breaks it down as to when he met these women and how he became, like, he would never admit that he was the father of these children or who the children are, whether they boys, girls, how old they are. But I'm thinking with Rashana, him and Rashana, if they really got a child together, that child should be a teenager or close to an adult. Don't y'all think? I don't know. Let me know. But anyway, Dana said that Rashana is not going to testify against R. Kelly, that she's sticking to her story, that was not her in that video, and that everybody's going to be surprised when the trial actually starts. Oh, and speaking of the trial, so we already know that the Illinois trial is supposed to start on April 20th. Well, yesterday, New York set their start date to May 18th. So I guess they think that the Illinois case is going to be wrapped up in a week or so, but they're trying to do these cases back to back. And then that the Chicago case, I believe it is set to start in April as well. So back to Dana J. What else did Dana say? I mean, he was just basically talking about, they were going back and forth about the money that's being raised and, how he's just the front man, but all the money is going to Doug Anton. And then Kevin was giving his perspective on why he doesn't think it's a good look for Dana, because so much controversy swirls around Dana, why he's not a good fit to be the front person, who's telling people to donate, and that if the attorneys are actually behind this defense fund and it is a legitimate defense fund, then they should be the ones that are coming out to the public and telling the public, like, hey, if you want to donate to R. Kelly's defense fund, this is how you do it. And then Dana replied something about some legal reason why the lawyers can't do it.
Every time we talked on the phone before we even got here, I said, Dana, listen here, man. I said, you got people rocking with you, man. I said, but with all that drama shit, motherfuckers ain't with all that. And I'm one of those dudes that ain't with all that. Listen, and this why it pulls my mind. If motherfuckers going to court against a motherfucker here in Chicago, and the motherfucker got something to do with it, we don't kick it with the opposition. We ain't got to talk. We don't talk. Listen to me, bro. This is real nigga shit. We don't talk to the opposition. Ain't nobody related to the opposition. Baby mama, daddy, cousin, none of that shit. If motherfuckers going against us, they just going against us. And this is why I say to you, I have a thought of my own, not like everybody else, because my thought saying like, damn, if it's true that you got a baby by Geronda and a baby by LaShonda, whatever fucking LaShonda and a baby by Ashanti McGee cousin, and then you fight for Kels this hard, that shit don't make no sense, bro. I'm speaking from real nigga shit. How is it like that? That's what I was trying to get you to break down to me, because I don't know, man. We just different breeds here. We don't rock with the opposition. If a motherfucker's against somebody in our family, bro, man, you against everybody. Ain't no fucking with the opposition. Ain't no other way around that. So that's why I was trying to figure how the fuck that's going.
Okay, but I'm gonna break down the whole thing. And the whole thing I'm gonna break down is from, but that's not when you say that dude inbox you on this old shit. Come on, man. But I'm gonna use some real shit.
Okay, all right, well, fuck all that. What the baby mama and shit, and you fight for Kel? How the fuck this all come in play? Cause you made a video saying that you got a baby by Shanti McGee daughter and a baby by LaShonda, but you fight for Kel so hard. How the fuck is this? How the fuck did that come around? Because to me, bro, and I'm just speaking from real nigga shit, that's opposition shit, bro. I'm just saying. So explain that.
But I'm asking this question. How is that opposition when those two, and I'm going to say this, those two have never turned on Raw. Never. Those two has went against the grain for Raw. So how is that opposition?
Okay, cause so you telling me, what's that, LaShonda? Was it?
But I'm gonna tell you flat out, Rashonda Lanford he is not testifying against Rob.
Okay.
At all.
All right.
And I'm gonna tell you what. Yeah, I'm gonna give you the breakdown. People say just because she's cooperating. Cooperating was when they came to Greg's house and they said, "Are you Rashonda?" And she said yes. And she said, when they asked her, "Can you come with us?" And she said, "Why?" And they gave her the spiel, and she said no and walked away. If you notice, they had not said anything else about her.
Okay, so what about the Shanti daughter? But what I'm saying, bro, is all these.
McGee daughter,
yeah.
Break it down. For the Shanti McGee daughter, she got put out the house, out of her mom's house, and bought out of her mom's house because she exposed her mom. And everybody has went to the legal team and for the thing and broke everything down. I got word that I'm supposed to be getting subpoenaed, and that's fine. My brother already got subpoenaed, so it's only a matter of time that I get it. And my thing is, when I go, I'm going to speak nothing but the truth. One thing they can't do is make me lie on that man. I've never, and I can say this, man, God can take all my kids right now. I've never seen that man with an underage child. Never. Have I seen him play some chicks? Yeah. But I'm going to keep it 100 with you. And matter of fact, send me your email.
So how long did you know Rashonda? Did you know Rashonda before Kels or after Kels?
I met Rashonda, it was at the show.
At the show?
When I first met Rashonda, we was kids. And it was at a show. And it was at a show when I first met her. I mean, my dad first.
But anyway, moving on. Then John Russell found out, I guess, that Dana was on this call. Oh, and then Kevin didn't even tell Dana that he was live. So when they called each other, Kevin was already live and I came in late, so I don't know if Kevin called Dana or if Dana called Kevin, but anyway, he was already on live when the call picks up. So then Don Russell sends a message through a friend of Kevin's that he wants to talk to Kevin. And so we were thinking it was somebody that wanted to offer Kevin a job because, you know, he let us know on his live on his Facebook page that he lost his job while he was on vacation a couple of weeks ago. So anyway, Kevin was like, oh, okay, well, you know, let me call the person. Well, it turns out that the person was Don Russell. And so Don Russell was basically, you know, saying that nobody should be given to this defense fund, which we've heard him say. And that's one of the controversies with the groups and everything that people belong to, is that they're giving conflicting and contradicting information. So people in the comments, myself included, was like, ask him this, ask him that, ask him this. And so Kevin asked Don Russell about the fake Kelly sisters. And so he confirmed that they are not R. Kelly's sisters. And he also said that it's not true that R. Kelly doesn't know who his father is, that R. Kelly has always known who his father is. But it was something about the father or something was going on that he never really talked about his father. And he also said that R. Kelly's biological father is deceased, but he is not the father of the Kelly sisters. And then he was asked about Levi. Is Levi really R. Kelly's cousin? And so he said that, well, yeah, sort of. You know, he's like, you know how they have like second, third, fourth cousins. So basically what that comes down to is Levi ain't R. Kelly's cousin. He is basically probably... You know how it is, especially if you're raised in the South, how you grow up with people. I know I used to go to Tallahassee all the time, and my cousins had cousins. And so to this day, we call each other cousins, but we're not really blood related to each other. But it's just because they were my cousins' cousins, then I said, okay, but they're my cousins too. So it sounds like R. Kelly may know who Levi is, but as far as them being first cousins and having a close relationship, that is not the case. And then the Darlene lady called in. I don't know who Darlene is, but Darlene was going off, and Kevin said he's going to try and get Darlene back on the phone later today to do a live with her. But Darlene was basically going in on Dana J, and she was like, she is R. Kelly's super fan, and she gonna cuss out anybody that ain't right and ain't doing right by Dana J. So I hope he go ahead and put the video up on YouTube, and if not, you can go and check it out on his Facebook page. So now let's go ahead and jump into these documents on this motion. And the reason I'm talking about this is because you guys know I like to bring you information. And then the other reason is because it just goes to show Steve Greenberg don't know what he's doing, okay? And I'm not a lawyer, but I'm just saying if he was my lawyer and this is what he was doing, I would probably fire him, and then maybe R. Kelly can't fire him because he can't afford to hire anybody else. But I really need Steve Greenberg to step it up and do better, just really do better. So let's go ahead and get into these documents. Okay, so this letter was written by a lady named Kimberly Faushauer. Faushauer is Fashauer, and she lives in Port Charlotte, Florida. And so she wrote this letter to the judge, Ann Donnelly, who was the one that sat in on the hearing yesterday. And I'm wondering what happened to the other, because I didn't know there was a lady in the New York case. And is the old guy, is he in the Illinois case? Remember the one that said he didn't know who R. Kelly was, or he didn't know R. Kelly was a superstar? Well, the judge in the Eastern District of New York is a lady named Ann Donnelly, and maybe I just overlooked the fact that it was a woman that was handling that case. So Kimberly writes, Dear Honorable Judge Donnelly, I, Kimberly Fausher, 42 years old, am writing this letter to you to provide a character reference about Robert Sylvester Kelly, whom I've known for over 10 plus years. I I was surprised to hear about his case, as he has always been a strong, business-minded, caring, humble person. It is for this reason I am happy to write a letter of reference for Mr. Kelly. I provide this reference in full knowledge of Mr. Kelly's charges, and I understand the seriousness of the matter. However, I hope the court will show him some leniency. Robert Sylvester Kelly has always been an upright character in many communities. Some to mention are, in 1995, Mr. Kelly has donated a large sum of money to a UK charity fund in London. In 2016, Mr. Kelly has helped a family in need, covering funeral costs for two young brothers who had died in a fire in Kankakee, Illinois. In 2017, Mr. Kelly has visited high schools. Tilden High was one of them, to play basketball with the young men, as well as shared stories and ups and downs, letting the youth know they can do anything they set their mind to. Mr. Kelly has also helped many churches, congregations, and gave money to the homeless. He made a point to be there and show significant amount of support selflessly to help others. In addition to the good he's done for the communities, he's written many songs that have helped many people through good and difficult times. Songs that inspired many. The World's Greatest, played at my nephew's graduation ceremony at Neil Armstrong Elementary School just last year in 2018. Other songs like Victory and Prayer, Changes, that encourage people to never give up, reach for their goals, and when you feel hope is all gone, pray. For myself, when my father took his life in his own hands 16 years ago, his music and one particular song, The Storm Is Over Now, believe it or not, helped me cope with my father's death. I didn't just hear the lyrics, I felt them. And it helped me understand what my father was going through, and it brought me comfort. I honestly and strongly believe Robert Sylvester Kelly is wrongfully accused and also not being treated fair as a United States citizen should, and it is my sincere hope that the court takes this letter into consideration. Despite the current case, I still and will always believe Robert Sylvester Kelly to be an honorable individual, a valuable member of his community, and a good, wholehearted human being, not a monster he's been painted out to be. Thank you for your time. Sincerely, Kimberly Foshire. I don't know if I'm pronouncing that correctly. So I'm reading this letter because when I went through the system, I wanted to see if there were more letters, like, maybe a whole bunch of people been writing on R. Kelly's behalf, but this was the only letter that was in the document system that I came across. And so I got to thinking, we got Dana J out here saying that R. Kelly mentored him and what a wonderful, father figure he was to him. Why isn't there a letter from Dana J about this? Then I think about Sharon, who said that she worked for him. Why isn't there a character letter for Sharon? We had Will, who was on Phases a few months ago, telling a story about they were playing basketball or something, and the lady got shot on the other side of the fence, and how they rushed over. So he told that story. Why don't we have a letter from Will attesting to R. Kelly's character? Like, why all these people who are coming out saying that they know him personally, they have these relationships that they can vouch for him, why hasn't any of these people come out and written these letters? Why hasn't Don Russell written a letter? Why hasn't the Ruby Chris guy, Bubba, why hasn't he written a letter to R. Kelly's character? And I would think that that would be something that a friend would do, and especially since these are the people that are saying that they know him. Kip, who else came on? The African John guy, the twins, Lindsay and Jen. Why don't we have any letters written to the judge from any of them? And I know they'll probably come back and say, oh, because we may be witnesses in the case. Well, unless you have already been named a witness, you should be done wrote a letter to the Northern District of Illinois, the Eastern District of New York, and even over there to Cook County, attesting to this man's character so that this stuff can be on file and noted in the record. So what do you guys think? Like, if you knew R. Kelly personally and you believe that he was innocent and was being railroaded, would you write a letter to the judge, on his behalf, or would you just sit back and, talk about all these great things that you're going to do for him, once he gets out, or you want to be a support system or whatever? Do you think that all these people that are coming out saying that they were close friends of his, or, they've had these relationships with him and they're fighting for him, why haven't they written letters? Why hasn't Jocelyn and Azriel written a letter to the court, as character witnesses, or offering to be character witnesses on his behalf? So I just thought that this letter, it was a nice letter, and that it was interesting, that this woman took it upon herself to write this letter. And I don't know if she wrote the letter on behalf of Steve Greenberg, if he reached out and asked her to write the letter. I don't know. The letter is dated September 18th, and it was put on file September 30th. Okay, and so next we have the motion that was filed by Steve Greenberg. And so this is United States versus Robert Kelly, and then it has the case number. And so the letter, it says, Dear Judge Dunley, my firm, along with others, represent Robert Kelly in this matter. And then, he's basically saying that he is submitting this motion for R. Kelly to get out of jail. And it says that pursuant to Magistrate Judge Stephen Tission, August 2nd, 2019 order, Mr. Kelly was denied pretrial release as a risk flight, and because he believed there was a possibility of obstruction. And then he talks about the transcript and where she can find what this judge stated. He says, Mr. Kelly similarly remains incarcerated pursuant to a July 16, 2019 order of detention entered by Judge Harry Lineweber. And I believe this is the old man. Okay, it says in the Northern District of Illinois. It says a request to reconsider that order is pending. A copy of the motion to reconsider is attached to this letter. And it says, we are respectfully asking the court to review Magistrate Tission's decision. The government failed to prove by preponderance of the evidence that Mr. Kelly poses a serious risk of flight, or that he is a danger to commit obstruction. The magistrate erred in concluding otherwise based upon the applicable facts and the governing legal standard. Mr. Kelly is presumed innocent. His case is defensible, and he does not have any criminal record. The government's argument that given the defendant's lengthy and wide-ranging history of obstruction, there are no conditions that can overcome this presumption and mitigate the risk of danger, flight, and obstruction, end quote, is predicated upon a presumption of guilt and requires the absolute acceptance of every factual inference without any consideration of the time period, prior testimony, lack of corroboration, or the advisory process. And then he goes on to say the government's argument for detention was also rooted in its claim Mr. Kelly has a, quote, lengthy and wide-ranging history of criminal conduct. And then he talks about the exhibit. He says this is unquestionably false and misleading given the fact that Mr. Kelly has never been convicted of any crime. The magistrate completely failed to consider this circumstance when Mr. Kelly was denied bail. Equally important, he gave no meaningful discussion to reasonable conditions. In purporting to set forth the applicable law in its July 12, 2019 letter to the court, the government incorrectly conflated the various factors to be evaluated under the Act. In reality, the Act mandates a simple two-step inquiry, and a defendant may be detained pending trial only if both prongs are satisfied. And then he gives the code. He says 8 USC, which is United States Code, 314.2 parenthesis E, and then 314.2 parenthesis F. He says, first, the government must demonstrate the defendant has been charged with one of the crimes enumerated in section 3142F and I, or that he presents a serious risk of flight of obstruction, and he gives the codes. Thus, no matter how dangerous an individual may be, he cannot be detained unless one of these initial conditions is satisfied. And it says, see Friedman, Supra, and he gives like a case study that supports what he's saying. He says, here the government contends there was a presumption of both a serious risk of flight and a danger to the community. That is wrong. Mr. Kelly does not present a serious risk or either flight or obstruction. And then he says, second, even where the government satisfies its burden as to the first prong, detention may be ordered only if no condition or combination of conditions can reasonably assure the defendant's presence and the safety of the community. In this case, any alleged potential risk that could conceivably exist can be sufficiently addressed through detailed conditions of release. In support of this application, we clarify and in some cases correct information that was presented or omitted and then relied upon by Magistrate Tission as the basis for his detention order. We also present new facts and additional legal arguments that we believe were not sufficiently addressed during Mr. Kelly's detention hearing. To summarize, the magistrate explained that a basis for his decision was that Mr. Kelly has access to financial resources and had engaged in frequent international travel, giving him an opportunity to flee. The magistrate also opined that, given the serious nature of the charges, he had a significant incentive to flee. So basically, Steve Greenberg is basically rehashing what has already been said in the previous motion in which they denied R. Kelly release. So I don't know why. I mean, he's just rewording what he's already said. And I'm guessing he's thinking because he puts this case law up. But I believe that because of the nature, like regardless if we believe that he committed the crimes that he's accused of, the nature of the crimes is what's preventing him from being released. And then he still has Azriel, who people are saying is one of the Jane Does in one of these indictments. And so I'm thinking, like, as long as he has her at that house, like he still has a relationship with her, that they're never going to let him go. And that's why I just don't understand. It just seems like Steve Greenberg needs to change his approach. He goes on in the motion to talk about it says, the fact is that Mr. Kelly possesses almost no financial resources and no evidence was presented to the court to the contrary. Indeed, there is nothing in the record to support such an inference. Likewise, Mr. Kelly is not a frequent international traveler. His passport is presently in the custody of authorities in Cook County, Illinois, in connection with Illinois state court proceedings. That passport was issued approximately 8 years ago and does not contain a single stamp for travel, which he has already said over and over again, and it didn't make a difference in the past. And so Mr. Kelly does not travel outside of the United States. Further, whatever incentive to flee Mr. Kelly had existed during his previous trials and current state court charges, these charges, each of which carried a 6-year mandatory minimum prison sentence, did not cause Mr. Kelly to flee. In fact, he showed up at each and every court date over a period of years. Once again, they've already heard all of this, so why keep going over it? It says, equally important, it is a serious risk of flight. And this is what they're claiming are the reasons that they're not letting him out. It says, not an incentive to flee. that is required to be considered. C. Friedman, and he talks about that case again, and it says that the government contends that Friedman presents a serious risk of flight because of the nature of the charges against him and the strength of the government's case, the long sentence of incarceration he may receive, his age, and the obloquy, obloquy that he faces in his community. And so he says the magistrate also expressed concern about potential future obstruction predicated upon the government's allegations of past obstruction. If the government was referring to the Northern District of Illinois indictment, the most recent alleged obstruction occurred nearly 5 years ago and is plainly mischaracterized within the charge. It was a civil settlement with a former manager following a lawsuit. Beyond that, those allegations are just that, allegations, and allegations not charged in the present indictment. To give them credibility and to obtain Mr. Kelly and to detain Mr. Kelly based upon them is to incarcerate him for a different charge without trial. So I guess there he's saying that they're talking about something that happened 5 years ago that the Darrell McDavid guy did, and because no charges were ever brought, and because no charges were ever brought in that instance or whatever he's talking about, that they can't use that as a reason to detain him now. And then he says, more to the point, the law speaks to the future, i.e., quote, a serious risk that such person will, end quote, not that they have been. And then he says, regardless of the past, any evidence or concern of future obstruction is unsupported, notwithstanding years of rumors that Mr. Kelly was being investigated, television shows dragging him through the mud, and the filing of serious charges earlier this year in Illinois State Court. The government cannot identify any instances where Mr. Kelly has tried to influence, intimidate, or tamper with a single witness or potential witnesses. To be sure, if there are any concerns about Mr. Kelly going forward, they can be addressed by way of conditions of release that bar Mr. Kelly from having contact with witnesses either directly or through third parties. And he says, since Mr. Kelly poses neither a serious risk or flight nor of obstruction, he respectfully requests that the court set bail and release him upon satisfying the conditions imposed by your honor. Mr. Kelly is prepared to consent to conditions of release that would substantially mitigate any potential risk and reasonably assure his continued presence before the court and the safety of the community. And then it goes on, and he has some bullet points. And so bullet point 1 was Mr. Kelly is well outside the class of individuals for whom pretrial detention is warranted. And he says courts should always, quote, bear in mind that it is only a limited group of offenders who should be denied bail pending trial. And then he gives some court cases. And he says the Bail Reform Act, hereinafter referred to as the Act, was expressly not intended to apply to all defendants charged with serious crimes, but only to that, quote, small but identifiable group of particularly dangerous defendants as to whom neither the imposition or stringent release conditions nor the prospect of revocation of release can be reasonably assured the safety of the community or other persons. And then he gives some other, a Senate report at 3189. And he's giving some jargon about where his supporting documents are. And he says, Mr. Kelly's continued detention is not justified on the facts. It marks a substantial departure from the class of cases in which pretrial detention has been deemed necessary to gather a sense of the type of, quote, particularly dangerous individuals whom Congress had in mind under the Act. One need look no further than the Second Circuit cases on pretrial detention and contrast those with the facts here. These cases confirm that Mr. Kelly is clearly not the type of person for whom pretrial detention was intended or is warranted. Mr. Kelly is in his 50s, does not have any criminal history, has never missed a court date, could not hide or evade surveillance given his fame, now has no passport, has posted a substantial bond in state court, has voluntarily turned himself in on all charges, and made no attempt to flee in the face of imminent federal charges, and is presumed innocent. He clearly is not within the limited group of offenders who should be denied bail pending trial. And then number 2, the government cannot satisfy the first requirement for pretrial detention under the Bail Reform Act. And then it says, A, Mr. Kelly presents no risk of flight. There is zero evidence from this court. There's no evidence for which this court can infer that Mr. Kelly is a risk of flight, let alone the required serious risk. To the contrary, Mr. Kelly's history directly undermines the government's unsupported assertions of flight risk. Perhaps most significant is Mr. Kelly's record of appearance. Mr. Kelly faced prior criminal charges in Illinois state court in the early 2000s, for which he was released pending trial and never missed a single court appearance. He was acquitted by a jury on all charges after weeks of trial. Mr. Kelly appeared dozens of times in that matter. He was never even late. Additionally, he was allowed to travel after returning. He was allowed to travel and always return. Here, the fact that he was being investigated by the federal government was well known. Certainly, he knew in the face of that, Mr. Kelly went about his normal activities. There was never any concern that Mr. Kelly was going to flee, notwithstanding the swirl of rumors of investigation and looming indictment. When the agents arrested him, he was walking his dog. He was fully cooperative, never attempted to flee. And once again, we've heard all this before. He said this when he filed the motion in Illinois. Equally, or perhaps even more importantly, when he was indicted for very serious charges in Cook County, Illinois, in the spring of 2019, he voluntarily surrendered the same day. When charges were added to that action and he was told that he had to appear in court for an arraignment on those additional charges, he promptly and voluntarily did so. Notably, the Illinois prosecutors did not even ask to increase or change any condition of his bond at that time. Last, instead of using the last of his money to flee, Mr. Kelly posted a $100,000 bond in the case. Additionally, it was misrepresented to the magistrate that Mr. Kelly travels internationally. He does not. His last international travel was approximately 8 years ago. Plus, because his passport has been surrendered, he cannot. Finally, there are various levels of monitoring or even home detention that would decrease any conceivable risk of him leaving or skipping out on bail. B. Mr. Kelly's personal history and characteristics. By way of further background, Mr. Kelly is a lifelong resident of Chicago. Prior to his detention, he resided in a one-bedroom plus modest den condominium with his 2 lady friends. And this is where he pisses me off. Like, stop mentioning Jocelyn and Azrael when you're going before this court. It says the building in which he resided is the Trump International Tower, a highly secure building with a 24-hour doorman and vast security. Mr. Kelly has a number of health issues which need to be addressed and for which he is not presently receiving adequate medical care. This includes numbness in his hand, anxiety, and an untreated hernia. His conditions of confinement, even after he was moved out of the special housing unit, remain stifling. He is limited to 300 minutes on the phone per month. His visits are severely restricted. Presently, he is only allowed 1 unrelated person to visit. In other words, although he lives and has lived with 2 lady friends, only one of them is allowed to be on his visiting list. And after 90 days, he is required to switch. No other friends or professional colleagues are allowed to visit. That is not right. Okay, now let's talk about them 300 minutes. Look, y'all talking to somebody that don't like talk on the phone. So 300 minutes though, I think most prisons, or I know locally prisons, they only get like 15 minutes to talk on the phone when they can talk on the phone. And I don't think they get phone privileges every day of the week. So that 30 minutes, I mean, even if 300 minutes, even if you said 30 minutes per phone call, which I think is an awful long time to be on the phone if there are other people waiting to use the phones. So that would be what, 10 phone calls a month. That's 2 phone calls a week. And now, granted, I'm somebody that don't like talking on the phone, okay? So maybe 300 minutes don't seem like a lot, because I know with my phone bill, I have unlimited minutes. And on average, I might use 170, 180 minutes per month. And I have unlimited minutes. So I don't know. I didn't see that as the 300 minutes as a bad thing, but I do wish he would stop talking about Azriel and Joycelyn. And then the whole thing with the visitors, and maybe it's different because he's not in a regular prison. I guess this is just a correctional place that holds people that are awaiting trial, or maybe they have permanent prisoners there. I'm not sure. But I would think that he would be anybody that could pass a security check. Seem like they should be allowed to be on his visitors list. And I know you usually only can visit once a week, and then I don't know if the same person can come over and over again, but the visitation part of that seems unfair to me, that he can't have non-family members on the list, and he can only have one non-family person. Like, to me, that seems strange, but maybe that's how it works. Not sure. Then C, Mr. Kelly presents no genuine risk of obstruction. It says, despite the government's burden of demonstrating that Mr. Kelly poses a serious risk of danger to the community, the government relied upon just one alleged instance of obstruction in its July 12, 2019 letter that is submitted to the court. It says the government relied exclusively on a letter that is related to a civil case. If this is a letter, Mr. Kelly did not write it. He can only write phonetically, although he does not deny someone may have asked him to sign something. He does deny he ever intended to threaten anyone. Mr. Kelly has never knowingly expressed any anger towards the individual in these materials. Moreover, Mr. Kelly has never engaged in any threatening or violent contact towards her. Now, who they talking about, y'all? If you know who they're talking about, can y'all drop that in the comments and let me know? And so it says, one of the Jane Does named in this indictment, number 5, filed a civil suit against Mr. Kelly last year. Her original attorney was convicted of fraud, and it appears at this point that Jane Doe is unrepresented. Okay, so we know that that's Faith Rogers, because y'all know her lawyer. If she ain't gone to jail, she about to go to jail for about 40 years or something, having to do with a case that she filed for her aunt, to kind of hide some real estate from a judgment that the aunt had received. And not only did she act as the lawyer, she acted as the real estate agent. And I think she benefited from the sale of this property, but the aunt really retained the property. They were just trying to be slick. So we know that this is Faith Rogers that he's talking about. It says, it is believed this is the individual who the government claims Mr. Kelly threatened. More to the point, after he was served with the civil complaint, an individual he knows prepared a series of documents, had him sign them, and then filed them on his behalf with the court. To the extent the government may have been referring to these documents, a copy is attached. See Exhibit C. They are plainly nonsensical. As in the presentation to the magistrate, the government referred to the potential that Mr. Kelly had potential witnesses or alleged victims write letters with false allegations that could be used against them. As with all allegations, no discovery has been produced that supports that claim, and thus it is difficult to respond to this alleged concern. Nor is there any evidence that if such letters in fact exist, Mr. Kelly has never used them. In sum, the government appears to claim that Mr. Kelly had people generate evidence to dissuade persons from cooperating with the government or to punish such persons if they cooperated with the government, but that such materials were never actually used to dissuade them or punish them. Likewise, the government claimed that Mr. Kelly threatened physical harm. However, again, there is no evidence of this, nor is there evidence of physical harm, evidence that anyone was ever physically harmed, or even any details providing the basis for such alleged threats. Lastly, the government claimed that Mr. Kelly created numerous recordings of minors and kept them at his disposal so that he could release them to deter the witnesses from cooperating with law enforcement. Apparently, this argument is, quote, so if you accuse me of doing something wrong, I will release the video evidence to prove it in order to punish you, end quote. This logic is nonsensical and has no basis in the record. Now that is true, okay, because so you're going to record minors to use as blackmail, but then if they go against you, you're going to release it, so wouldn't that put you in jail anyway? Just stupid. And I just can't believe that the government is wasting tax dollars on this nonsense. It says the government also claimed that Mr. Kelly continued to commit crimes while he was released on bail in his 2002 Illinois case, referencing allegations of kidnapping and sexual assault. As support for those allegations, the government references Jane Doe number 2 in the indictment, who appears to be an adult. Notably, this individual never complained about her interactions with Mr. Kelly until quite recently, 2 decades after the conduct allegedly occurred. Given the secretive nature of the government's disclosures to date, defense counsel cannot further respond because they do not know the identity of this individual. But again, Mr. Kelly is presumed innocent of the charges in the indictment, and such conduct cannot form the basis of his detention. In the interest of full disclosure, the Illinois federal court indictment alleges that Mr. Kelly engaged in certain activities while he was previously out on bail in the Illinois court case in the 2000s. An individual made a complaint against Mr. Kelly known during the pendency of that case. That complaint was, at that time, fully investigated by the Chicago police and Cook County prosecutors. Ultimately, no charges were ever brought against Mr. Kelly in response to those allegations. The allegations, now being remade more than 15 years later, do not appear to have any new or additional basis. So we know in this case they are talking about Lanita Carter. She was the one that said she was his hair braider, and she was called over to the house to braid his hair, and that he forced her to have oral sex with him or perform oral sex on him. Y'all remember, and then the video came out where she was doing the spoken word piece where she was bragging about the fact that she loves performing oral sex. So it says, significantly, Mr. Kelly's co-defendants in the Illinois federal case, who have also similarly been charged with the very same alleged obstruction activities as Mr. Kelly, have been released from custody, and one is in Las Vegas. Darrell McDavid, who was released on a $500,000 bond, and then Milton Brown, I don't think, had a bond issued in his case, and he was allowed to return to Las Vegas, where he now lives. And then it closes out on this section saying, in any event, to the extent the court believes that a significant risk of obstruction exists, that risk can be adequately alleviated as discussed below through conditions of release such as a prohibition on contacting co-defendants, and potential witnesses, as well as tight restrictions on Mr. Kelly's travel. And then part 2, it says the government cannot satisfy the second requirement for pretrial detention under the Bail Reform Act. It says even in cases in which the government can demonstrate a serious risk of flight or danger to the community, the act instructs courts to order pretrial release, quote, subject to the least restrictive further condition or combination of conditions that the court determines will reasonably assure the appearance of the person as required and the safety of any other person and the community. And then it cites the United States Code. And it says pretrial detention is permitted only if the court finds that no, quote, condition or combination of conditions, end quote, of release would, quote, reasonably assure, end quote, the defendant's appearance and the safety of the community. And then it cites the code and it says this is plainly not such a case. Ample conditions exist that would assure defendant's appearance and court and would mitigate whatever risks exist to the community. In evaluating whether conditions exist to reasonably assure a defendant's presence and the safety of the community, the Act requires the court to consider 1. The nature of circumstances of the offense charged, including whether the offense is a crime of violence, 2. The weight of the evidence against the person, 3. The history and characteristics of the person, and 4. The nature and seriousness of the danger posed by the person's release. And then it gives the code, and these factors weigh heavily in favor of Mr. Kelly's release. It goes on to say, first, since the July 12, 2019 detention hearing, no evidence has been disclosed to the defense showing that substantial evidence supports the indictment. Defendant can only guess that the indictment is merely a holding charge for a pending superseding indictment charging an actual RICO conspiracy involving more than one person, and thus that the current indictment was issued for the sole purpose of attempting to arrest Mr. Kelly prior to federal prosecutors in Chicago. So what he's saying there is, because they haven't really given him any evidence or any proof to substantiate what he's saying, that this, what they're charging him with now, may not stand, and that it's sort of like a placeholder, like we're going to put all these charges against you while we continue to investigate and get our documentation and whatever in order, and then they'll come back with a bigger charge or a bigger case that will supersede this case. So this case will get wiped away, and then whatever they come up with as far as evidence and being able to prove their case will be the actual charges that he goes to court for. And it says, second, with respect to the history and characteristics of Mr. Kelly, he has strong family ties in the community, has lived in the community for over 50 years, and has a perfect, unblemished, quote, record concerning appearance at court proceedings. And then it gives the codes, and it says, moreover, at the time of the current offense or arrest, he was not on probation. And then it gives the code supporting that. Third, as to the nature and seriousness of the danger, and they have danger in quotation, purportedly posed by his release, the Pretrial Services Department is perfectly capable of monitoring Mr. Kelly and preventing him from contacting alleged victims. Moreover, the government likely has its witness tightly under wraps, being monitored closely by FBI agents and by victim specialists. Should Mr. Kelly even attempt to contact one of them, assuredly they would immediately tell the FBI or the coordinator, causing this court to revoke the pretrial release, which makes sense. Like, why would he be so stupid as to try and contact the people and, you know, intimidate them or whatever, knowing the seriousness of the case? And then fourth, it says pretrial services in the Northern District of Illinois recommended release with conditions, while pretrial in the Eastern District of New York did not. There does not appear to be any reason They did not explain one and do not appear to have one. And so I was wondering the other day, and I think I asked somebody, when they're talking about the pretrial services, are they referring to the Chicago pretrial services, which Judge Flood in the Chicago case, he terminated the pretrial services because he was like, the federal cases supersede their case, so there was no need to keep that order in effect. But here he's saying that the Northern District of Illinois, which is the federal case, that they've also done pretrial services and recommended that he be released. But in this document, release is italicized, so I don't know the significance of that. And then it says, finally, because of the fundamental importance of Mr. Kelly's interest in liberty, and then it gives a code. Explaining what liberty is and what case they're citing. This court also should consider the anticipated length of his pretrial detention. And then they give some more case study, noting that a substantial delay may require the government to make a heightened showing of dangerousness of risk of flight. This too weighs strongly in favor of Mr. Kelly's release pending trial. Mr. Kelly already has been detained for approximately 3 months, and a trial, which will likely last more than 1 month, is unlikely to begin any sooner than sometime in early to mid 2020. Thus, if the court continues to deny his pretrial release, Mr. Kelly undoubtedly will suffer a prolonged period of detention before a determination ever is made about his innocence or guilt. Notably, the Bail Reform Act is expressly not intended to affect the presumption of innocence, and it gives the code. And then we already know that they set the trial date for the New York case for May 18th of 2020. Then section 3 is the conclusion, and it says, fully consistent with the intent of the Bail Reform Act, as well as constitutional limitations on the deprivation of an individual's liberty, pretrial detention is reserved only for those defendants who are particularly dangerous and who pose a serious cognizable risk of flight or danger to the community. Mr. Kelly does not fall into the narrow category of people because conditions of release exist in this case that would realistically eliminate any purported risk of flight or danger to the community. The court should release Mr. Kelly subject to whatever conditions is deemed appropriate. Thank you for your consideration of this application. Respectfully submitted, Steve Greenberg. He made his case, like it's pretty much the same case that he made a couple of months ago, and it did not give him the results that he was expecting. Not sure why he thought that it was going to be any different, unless he's basically trying to get all of this stuff on the record in case there is an appeal. And I guess so we can see what's going on also once we get hold to these documents. And so the judge had not received a response from the prosecution, and so she issued an order telling them that they had until 12 o'clock on October 2nd to respond to the motion, and this is what they had to say. Dear Judge Donnelly, pursuant to the court's September 30th, 2019 order, the government respectfully submits this letter in opposition to the defendant Robert Kelly's September 30th, 2019 motion for pretrial release for the reasons set forth herein and in the government's July 12, 2019 detention memorandum, a copy of which is attached hereto. The government respectfully submits the order of detention issued by the Honorable Steve Tyson should remain in place, and the defendant's motion for pretrial release should be denied. Number 1, applicable law. As the defendant highlights, there are 2 steps in the detention inquiry. First, to hold a detention hearing, the court must determine whether the defendant has been charged with a qualifying offense or if a qualifying circumstance exists. If a detention hearing is warranted, the court must then determine whether any conditions or combination of conditions will reasonably assure the appearance of the defendant as required and the safety of any person and the community. The first step is easily satisfied here on three different independent bases. First, the defendant is charged with a qualifying offense, namely a felony that involves a minor victim. And then it gives the court statute, and it says, indeed, the racketeering offense charged in count one includes multiple racketeering acts involving three different victims who were minors when the charged racketeering acts were committed. Jane Doe number 1 and Jane Doe number 4. Second, two qualifying circumstances exist that warrant a detention hearing. One, the case involves a serious risk that the defendant will flee if released, CID, and then it gives the codes. And two, the case involves a serious risk that the defendant will attempt to obstruct, threaten, intimidate, or attempt to threaten or intimidate a prospective witness, and then it says CID, which is the codes. Each of these factors serves as a standalone basis for the court to hold a detention hearing. Once the first step is satisfied, the court must determine if, as the government submits, there are no conditions to mitigate the risk of flight, danger, and obstruction if the defendant is released. In addition, whereas here, there is probable cause to believe that the defendant is committed offenses, including minor victims under 18 U.S. Code 2251, sexual exploitation of children, 2421, transportation, 2422, coercion and enticement, and 2423, transportation of minors. It shall be presumed, subject to rebuttal, that no condition or combination of conditions will reasonably assure the appearance of the defendant as required and the safety of the community. And then it gives the codes that support that. And then, in presence of an indictment returned by a duly constitutional grand jury, conclusively establishes the existence of probable cause for the purpose of triggering the rebuttable presumption set forth in 3114E United States versus Contreras, and then it gives the codes for that trial. The number 2, discussion. In accordance with the rebuttal presumption applicable here, no conditions or combination of conditions will reasonably assure the defendant's appearance as required and the safety of the community. A, the defendant poses a serious risk of flight. First, as the government argued in its July 12, 2019 detention memorandum, the defendant poses a serious risk of flight if released. As an initial matter, the defendant's appearance as prior court proceedings in connection with the 2002 Cook County case is hardly indicative of whether, if released, he would appear in connection with the case. He is now facing charges in 4 different jurisdictions, including 2 in federal court. The charges in this district, the Eastern District of New York indictment, the charges pending in the Northern District of Illinois, the Northern District NDIL indictment. If convicted of certain of these charges in the Northern District of Illinois indictment, the defendant faces a minimum sentence of 10 years imprisonment. Given the breadth and quantity of allegations in both federal districts, he is facing substantially more time in prison than he did in connection with his 2002 case, providing an increased incentive to flee. Moreover, in connection with his 2002 case, the defendant paid witnesses a substantial sum of money to ensure that they did not testify against him, greatly reducing the likelihood of a conviction and therefore his incentive to flee. Second, the defendant's argument regarding his lack of international travel is misleading. While the defendant may not have traveled internationally in recent years, it is not true that he lacks the ability and desire to do so. Indeed, this year, after he had been released on bail in his current Cook County case, he sought to travel to Dubai with his 2 living girlfriends, each of whom took steps to accompany him by submitting applications to obtain their own passports. Indeed, his desire to travel abroad is likely even higher given his diminished stature here in the United States. This is another factor that demonstrates his risk of his flight. Now, my thing with that is Jocelyn and Azrael are both adults. So if they want to get a passport, they are certainly within their rights to get a passport. So why that would play any role into them thinking that he is a greater flight risk because they have passports make no sense. And what they're referring to is when they were trying to book the concert in Dubai. And I believe that if the judge had allowed the Judge Flood from the Chicago case would have allowed him to travel, more than likely they would have had to incur the expense of U.S. Marshals traveling with him to ensure that he got over there and that he returned. And then you guys remember Kim Fox sent Eddie Johnson over to Dubai to make sure that that concert didn't happen, because he just coincidentally went to Dubai around the same time that it was talks about him doing a concert over there. And it says, third, the defendant's contention that he has, quote, almost no financial resources, end quote, is also misleading. In fact, the defendant continues to receive hundreds of thousands of dollars in connection with royalties he is owed for his music. The government's investigation has revealed that earlier this year, the defendant redirected those royalties to the bank account of a childhood friend. Regardless of where those funds are being held, however, they belong to the defendant, and at any time the defendant can redirect those funds and future royalty proceeds earned to an account to his name. His lack of candor with the court regarding his financial resources is another factor that counsels against release. In sum, as set forth herein in the government's July 12, 2019 detention memorandum, the government has established by a preponderance of the evidence that there is a serious risk of flight if the defendant is released. We all know he was hiding that money because he didn't want Drea to get hold to it when it came to that child support. And then this also goes to show that this was how he was able to repay the Valencia Love lady the money that she put up for him for bond, because he wasn't able to access the money at the time. Okay, so then it goes on to B, the defendant poses a serious risk of obstruction. It says, as the government also argued in its July 12, 2019 detention memorandum, if released, there is a serious risk that the defendant will obstruct, attempt to obstruct, threaten, intimidate, or attempt to threaten or intimidate one or more prospective witnesses. First, and significantly, the Northern District of Illinois indictment charges the defendant with obstruction related to the criminal charges initiated against him in Cook County in 2002. As such, given the Northern District of Illinois grand jury's indictment, there is probable cause to believe the defendant has a prior history of committing obstruction when faced with serious criminal charges. And so I noticed that they cite a lot about the Northern District of Illinois case, but this is the Eastern District of New York case. So why are you using, like, is your case not strong enough that you have to go and start borrowing stuff from the Illinois case to build your argument here, especially considering the Northern District of Illinois has already agreed that he is eligible for the pretrial release. So that doesn't make any sense to me either. So it says, second, as described in the government's initial detention memorandum in 2018, the defendant or individuals acting on his behalf and under his control sent a typewritten letter to a lawyer then representing Jane Doe number 5, threatening to release compromising and potentially embarrassing photographs of Jane Doe number 5 if she pursued her civil lawsuit against the defendant. The defendant appears to concede that he was asked to sign and did sign a series of documents, and that those documents may have included the letter to Jane Doe number 5. Number 5's then lawyer, but then denies any knowledge of the contents of that letter. And it says the letter sent, which was provided to the defense as part of the government's discovery, Exhibit 72, includes certain photographs and screenshots of text message exchanges between the defendant and Jane Doe number 5 taken from the defendant's phone. The defendant cannot credibly deny his role in intimidating witnesses. By actions have shown that he cannot be trusted to follow an admonition by the court not to do so. Witnesses, by claiming self-servingly that he could not have written the letter due to his allegedly limited reading and writing skills, where he provided the material used to make the threats and signed his name to the accompanying documents. So we know that Jane Doe number 5 is Faith Rogers. So no guessing about that. Now my thing is, what was these text messages that he was sending with these threats? And you guys remember this whole story about the threats came out right before the Surviving R. Kelly docuseries aired. And remember, there was supposed to have been a Facebook page and a website that, you know, all of these things were shut down, but it seems like they weren't able to link it back to him. So people were saying, well, maybe it was like a fan or something who was doing this. And then it's so easy to pull stuff off the internet, because I mean, look at Faith Rogers, even since all of this went down, how she's been doing all these videos at the club, in a room, dancing, twerking to the camera and all of that. So it would be easy for anybody to get this information. But according to this, the information was in R. Kelly's phone. Excuse me. The information was in R. Kelly's phone, and that's where they retrieved. And then third, as described in the government's initial detention memorandum and detailed at the August 2nd, 2019 detention hearing before the Honorable Stephen Tission, the government proffered evidence that the defendant has a history of coercing women to write letters containing false and embarrassing allegations so that the defendant could use those letters as blackmail. Multiple witnesses have reported that the defendant directed them to write these embarrassing and false letters, and the similarities among the accounts by multiple witnesses lends credence to their accounts. In addition, at the August 2nd, 2019 hearing, the government proffered that witnesses have advised that the defendant issued veiled threats designed to prevent witnesses from testifying against him. Specifically, with respect to multiple women, he directed the women, prospective witnesses against him, to pick a side and strongly implied that choosing the wrong side, i.e. not his side, would result in harm to them or their families. Finally, the government has obtained records showing that in at least one instance, a young woman reported to law enforcement criminal behavior by the defendant, and the defendant thereafter paid the woman hundreds of thousands of dollars to enter into a non-disclosure agreement, thereby deterring future cooperation with law enforcement. Evidence supported this allegation consists of police records documenting criminal allegations and bank records documenting the ensuing payoff. And then it says, in sum, the government has established by a preponderance of the evidence that the defendant's release presents a serious risk of obstruction of justice. And then C, there are no conditions sufficient to mitigate the risk. There are no conditions that could effectively mitigate the risk of flight, obstruction, and danger. As noted above, whereas here there is probable cause to believe that the defendant committed offenses involving minor victims under 18, and then it gives those codes again. The court shall presume, subject to rebuttal, that no condition or combination of conditions will reasonably assure the appearance of the defendant as required, and the safety of the community, and it gives the code. The defendant has not rebutted the presumptions here. And then it says conditions such as home detention and electronic monitoring are sufficient to mitigate the risk. Moreover, as the Second Circuit has explained, quote, home detention and electronic monitoring at best elaborately replicate a detention facility without the confidence of security such a facility instills. And then it says United States versus Millen, and it gives the court codes, and it says such restrictions would not prevent the defendant from contacting and intimidating witnesses over the phone. Similarly, those restrictions would not prevent the defendant from directing the women with whom he lives and others who are not subject to the court's orders from contacting witnesses electronically or in person. And it says the defendant suggests that the court's order setting forth conditions of release is sufficient to prevent him from violating the court's restrictions. Not so. His past is a solid indicator, and it shows that he has a track record of non-compliance, a fact that weighs heavily against the notion that he will be compliant now, particularly under those circumstances where the stakes are even greater. As counsel concedes, one of the crimes alleged in the Eastern District of New York indictment against the defendant occurred while the defendant was on bail in connection with his 2002 case when Jane Doe No. 2 did not report this conduct to law enforcement prior to the government's recent investigation. Jane Doe No. 2's account of having been held in a room for multiple days without her consent is corroborated by accounts made by others by Jane Doe No. 2 at the time of the crime's occurrence. In addition, as the defendant also concedes, the obstruction charged in the Northern District of Illinois indictment includes conduct that took place while the defendant was on bail in connection with his 2002 Cook County criminal case. And then they have the letter that whoever Jane Doe No. 2 submitted to them as evidence, but it has been redacted, so it's just a big blob of blackness going on right here. And then it says, in sum, the defendant cannot overcome the presumption that no condition or combination of conditions will reasonably assure the appearance of the person as required and the safety of any other person and the community. And then it gives the code, and the defendant's motion to be released should be denied. And so where this doesn't make sense is that, remember, Angelo Clary and Tim Savage and all of them had been talking for months about all these people were meeting with the feds, all that this indictment was coming. So if he was going to intimidate anybody, try to obstruct anything, he would have did all this the months leading up to the actual indictment coming down and him being swiped up off the street while allegedly walking his dog, which is starting to sound more and more suspect. That we talked about this before. Like, why is there no video footage from any of the businesses around where he was picked up? Why has nobody who was driving down the street, because it's a major street, why, has nobody come along and said, yeah, I did see R. Kelly get swooped up by the feds while he was walking his dog? And then more importantly, how did the dog get back to the to Trump Tower if he was walking the dog when they picked him up? But anyway, Part 3, sealing. It says, because this letter potentially indicates one or more persons in uncharged criminal activity, the government respectfully requests that this letter be filed under seal, United States versus Amadio. And then they give the case information. Privacy interests of third parties may be compelling reason justifying sealing under the circumstances of the privacy of interest. And they're basically just talking about whatever that was redacted from this document, that it will be sealed and nobody can see who wrote the letter. But I think we can figure out who wrote it, because we already figured out who these Jane Does are. That's basically respectfully request that the court record those findings and file this letter under seal. The government will publicly file a redacted version of this letter, redacting those portions that potentially implicate the defendant and another individual in uncharged criminal activity. Respectfully signed, Richard P. Donahue, United States Attorney, and then Elizabeth Gans, Nadia Shahatu, Maria Cruz, Melendez, Assistant U.S. Attorneys. Okay, and then the last document that we are going to go over is actually the discovery. This is dated August 15, 2019. And it says by Federal Express and ECF, and it's to Steve Greenberg, and it has his address. And it says, Dear Mr. Greenberg, enclosed, please find the government's discovery in accordance with Rule 16 of the Federal Rules of Criminal Procedure. The government also requests reciprocal discovery from the defendant. And it says, 1, the government's discovery. A, statements of the defendant, the defendant's criminal history, and documents and tangible objects. Please find enclosed a thumb drive that contains the following items. These items are subject to the terms of the protective order entered by the court on or about August 13, 2019. And it's a long list, y'all. But here it goes. American Airline records for Robert Kelly on January 21st, 2012, January 23rd, 2012, and April 27, 2018, and records for Jane Doe number 4 on April 29, 2015. Delta Airline records for Robert Kelly on December 14, 2010, April 13, 2011, and May 4, 2011. Business records certification. American Airlines records for Jane Doe number 5 on February 2nd, 2018, and February 4th, 2018. Southwest Airline records for Jane Doe number 4 on August 30th, 2015. Business records certification. Southwest Airline records for Jane Doe number 5 on April 21st, 2017, May 18th, 2017, May 20th, 2017, June 16th, 2017, December 1st, 2017, December 3rd, 2017, January 12th, 2018, and January 14th, 2018. United Airlines records for Jane Doe number 4 on September 20th, 2015. Business records certification. U.S. Airways records for Jane Doe number 4 on May 2015. And I think we know that Jane Doe number 4 is Azriel because this sounds like Azriel. And so business record certification. Oh, and I'm going to stop reading business record certification because that is the receipt certifying that the information was put into the package. U.S. Airways flight manifest for May 2015. And remember, the May 2015 airline tickets is the ones that the Clarys presented. And it was basically a concert that R. Kelly had in the San Jose Jazz Festival in California. You guys remember in the previous video, I showed you guys the flyer for that concert along with these tickets that they showed of Azriel flying back from California, but they didn't show the ones of her going. And then it says SunTrust Bank records for Robert Kelly, R. Kelly Publishing Incorporated, and RSK Enterprises LLC. Wintrust Bank records for Phenomenon Entertainment Worldwide. Bank of America records for Milton Brown and RSK Entertainment Worldwide Incorporated. JP Morgan Chase records for Milton Brown, Robert Kelly, RSK Enterprises LLC, and Daryl McDavid. Lakeside Bank records for Bass Productions Limited. JP Morgan Chase records for Daryl McDavid and Robert Kelly. Bank of America records for Jones Entertainment Group Incorporated, Jones Consulting Group, and Gerald H. Jones. Citibank records for Daryl McDavid. Self-Help Federal Credit Union records for Kelly Home Account and Base Productions, Bass Production Limited, Consensia LLC records for Robert Kelly and RSK Enterprises LLC. Citibank records for Daryl McDavid, 310 Madison LLC, Winkler and McDavid, Winkler and McDavid Limited, 108 Kinsey LLC, and Daryl McDavid Revenue Trust Fund. American Express records for Daryl McDavid, Citibank records for Daryl McDavid, SunTrust records for Robert Kelly, Wintrust Bank records for Phenomenon Entertainment Worldwide, Self-Help Federal Credit Union records for Bass Productions, R. Kelly Touring Incorporated, Kelly Home Account, and Milton Brown. Medical records for Robert Kelly, Walgreens records for Robert Kelly, Quality Urgent Care records, University Health Systems records, birth certificate for Jane Doe number 4, Hilton Long Island Huntington records for various individuals, including Jane Doe number 5, from May 17, 2017 to May 20th, 2017. Statler Dallas records for various individuals from December 1st, 2017 to December 7th, 2017. Foxwoods Resort Casino records for various individuals, including Jane Doe number 4, from 7/16/2015 to 7/23/2015. West Chicago Lakeshore records for various individuals, including Jane Doe number 4, from November 12th to November 16th, 2015, and November 22nd to May 22nd, 2016. November 22nd, 2015 to May 22nd, 2016. Mundrin Park Avenue records for various individuals from January 25th, 2018 to February 2nd, 2018. Baccarat Hotel records for various individuals from July 13, 2015 to July 17, 2015. Intercontinental Chicago Magnificent Mile records for various individuals, including Jane Doe number 4, from June 16, 2015 to June 19, 2015. Walt Disney World Dolphin Hotel records for various individuals from April 20th, 2015 to April 24th, 2015. Night Hotels Times Square records for various individuals from July 12, 2015 to July 16, 2015. Four Seasons Baltimore records for various individuals from October 1st, 2016 to October 2nd, 2016, and July 28th, 2017 to July 30th, 2017. Planet Hollywood Resort and Casino Las Vegas records for various individuals, including Jane Doe number 4, from May 5th, 2017 to May 7th, 2017. Doubletree Chicago Magnificent Mile records for Jane Doe number 4 from June 23rd, 2015 to July 1st, 2015. Child, Azrael was living the life, wasn't she? And I guess the other individuals would be Jocelyn and then whoever, security or whatever, was traveling with them. Hotel Felix Chicago records for Jane Doe number 4 from May 29th, 2015 to June 5th, 2017, and September 21st, 2015 to September 24th, 2015. Now, why would Azrael need hotel rooms in Chicago if they lived in Chicago? Courtyard by Marriott Sacramento Folsom, and I actually have stayed at this Marriott when I went to see my daughter in November of last year. Okay, for various individuals, including Jane Doe number 4, from October 3rd, 2015 to October 4th, 2015. Courtyard by Marriott Newark records for an individual from July 18, 2015 to July 19, 2015. West New York Times Square records for various individuals from October 7, 2016 to October 8, 2016. Preferred Travel records for various individuals. Subscriber records for Apple Incorporated. Subscriber records for Apple Incorporated, subscriber records for Apple Incorporated, subscriber records for Apple Incorporated, subscriber records for Oath Holdings Incorporated, subscriber records for Oath Holdings Incorporated, subscriber records for Oath Holdings Incorporated, Uber Technologies Incorporated records, Uber Technology Incorporated records, NRG Recording Studio records, including receipts, work orders, invoices, payments, floor plans, and photographs of the facilities. Empire CLS records for various individuals, including Jane Doe number 4. Live Nation records, including touring schedules for R. Kelly. Chicago Motor Cars records, Screen Actors Guild, American Federation of Television and Radio Arts, SAG-AFTRA records for Robert Kelly. Sound Exchange Incorporated records, Broadcast Music Incorporated records, Business Records Certification, okay, skip that. Artist Rights Management records, Highs Limousine Worldwide records from July 18, 2015 to July 19, 2015. Snap Incorporated records for Jane Doe number 4. Is that Snapchat, y'all, or is that Snap as in the food benefit cards? I'm confused right there. Florida Virtual School records for Jane Doe number 4. So we definitely know Jane Doe number 4 is Azriel, because remember she finished school using Florida Virtual School, which is online classes. Criminal history reports for Robert Kelly. Text messages, pictures, and social media communication between Jane Doe number 4 and Jane Doe number 4's friends. So I guess Azriel was texting her homies. Text messages, pictures, and social media communications between Jane Doe number 4 and Jane Doe number friends again. Documents from Jane Doe number 4's parents. Documents from Jane Doe number 4's parents. Letter and attachment dated October 22nd, 2018. A photograph, a pamphlet, abandoned property, license plate recognition reports, United States Postal Service records, business records certification, Illinois Secretary of State records, including entity information and annual reports for Bass Productions Limited, R. Kelly Publishing Incorporated, and RSK Enterprises LLC. A search warrant returned from Apple Incorporated, and that probably was trying to get into his computer. AT&T Historical Sales Site search warrant return. Text messages, pictures, emails, and audio recordings provided by Jane Doe number 5. And we know that's Faith Rogers, right? Chicago Tracks floor plans, and then they have Homewood Suites Chicago records for various individuals from March 28th to March 31st, 2017, May 30th to June 22nd, 2017, June 4th to June 7th, 2017, June 4th to June 13th, 2017, June 14th to June 18th, 2017, July 17th to July 18th, 2017, July 20th to July 29th, 2017, August 12th to August 25th, 2017, August 30th to September 3rd, 2017, September 7th to September 18th, 2017, September 25th to October 18, 2017, January 6, 2017 to January 12, 2017, January 20th to February 11, 2017, February 27th to March 2nd, 2018, March 23rd to March 28th, 2018. So I don't know who he was putting up in all these hotels in Chicago. But I guess when you have company coming in, you live in a 1-bedroom condo, that you have to put people up in hotels. And also interesting is that in the response to Steve Greenberg, they only mentioned that one condo. So remember, there was all this confusion about there might be 2 condos. I think that there's only one condo. And then also in this, they talk about the Oath Holdings Company and connecting that to Jane Doe number 4, which is Azriel. So that might be the second condo, because Angelo claims that the second condo is in Azriel's name. So maybe that's why they have those records. And then the last thing they have is Holiday Inn Express, North Hollywood, records for various individuals from November 19, 2017, December 14, 2017 to December 30th, 2017, and January 15th to January 24th, 2018. The government is also in possession of documents and digital media that was seized from 401 North Wabash Avenue, apartment 48F, Chicago, Illinois. Upon completion of the government's review of the digital material seized, the government will provide to the defense copies of the seized digital media of otherwise make it available. You may examine the physical evidence discoverable under Rule 16, including original documents, by calling me to arrange a mutually convenient time. B, reports of examinations and tests. The government will provide you with copies of any reports of examinations or tests in the case as they become available. C, expert witnesses. The government will comply with federal, it says FedR crime P, and then it gives the code and several codes, and notify you in a timely fashion of any expert that the government intends to call at trial, and provide you with a summary of the expert's opinion, the identity, qualifications, and basis for the conclusions of each expert will be provided to you when they become available. D, Brady material. The government is not aware of any exculpatory material regarding the defendant. The government understands and will comply with its continuing obligations to produce exculpatory materials as defined by Brady versus Maryland. Before trial, the government will furnish materials discoverable pursuant to Title 18, and then it gives the codes, as well as impeachment materials, and then it gives the case, other crimes, wrongs, or acts. The government will provide the defendant with reasonable notice in advance of trial if it intends to offer material under federal ruling evidence 404B. 2, the defendant's required disclosures. The government hereby requests reciprocal discovery under Rule 16B of the Federal Rules of Criminal Procedure. The government requests that the defendant inspection and copying of 1, any books, papers, documents, data, photographs, tapes, tangible objects, or copies or portions thereof that are in the defendant's possession, custody, or control, and that the defendant intends to produce as evidence or otherwise rely on at trial. 2, any results or reports of physical or mental examinations and or scientific tests and experiments made in connection with the case, of copies thereof that are in the defendant's possession, custody, or control, and that the defendant intends to introduce as evidence or otherwise rely upon at trial, or that, and it just goes on and on and on about what they expect the defense to turn over. 3, emails sent and received by defendants incarcerated at the Bureau of Prisons. And it basically says the government may request that the Bureau of Prisons produce the government emails sent and received by the defendant during his period of incarceration. Number 4, future discussions. If you have any questions or requests regarding further discovery or deposition of this matter, please do not hesitate to contact me, blah, 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 Richard P. Donahue. So yeah, there you have it. That was the motion filed, the response, and then a list of all the discovery items that have been turned over to Steve Greenberg. Even though he claims he doesn't know anything, he doesn't have any information, this is what they turned over to him. And maybe there's nothing substantial in that once you pick through it and look at it that pretty much tells him anything. And then they're still referring to the people as Jane Doe's, so maybe he doesn't know who those people are. But if he just checked with us, we can tell him who the people are. But I'm sure he already has a good idea. So I know that was a long reading, but I just kind of want to, you never know 10, 20 years from now who will be looking into the R. Kelly case and won't be able to find some of the information. And they can look at these YouTube videos and it's read for them right here on the record. So anyway, guys, let me know what you think about the status of these cases. What do you think is going on? What did you think about the call? I want you guys to go and listen to the full 2 hours of that call with Dana J, Don Russell, and this woman named Darlene, who all called in on this call with Kevin Terrell, and then you can listen to it for yourself. I mean, for me, it was more comedic value than anything of substance, because you know how I feel. So anyway, go ahead, leave your comments, rate the video, and subscribe to the channel if you haven't done so already. And until the next time, I shall talk to you guys later. Bye-bye.